charged with murder and are found guilty of murder, you know, at some point you could get probation for murder. And I know some people who have been convicted of murder, and you know what they say, you know, prison is really not the place for me. It's really not going to help me. I need to be on the outside. Dylan Bell.
Yes, Your Honor, present.
All right, this is sentencing.
Yes, that's correct, Judge.
All right, and state on this one, the court had a question, or the court wanted the criminal history and whether there was any gang affiliation.
Also, Your Honor, as a housekeeping matter, I was appointed less than 10 days, so I don't know if on the record we need to address that before we begin.
Oh, no, we did address it on the, because he wanted to go forward with sentencing. I said, please don't do this because,
I remember, yes.
yes, but we'll put it on the record as well. Well, before we go on the record, Mr. Bell, would you like to give your attorney more time to prepare a mitigation packet for you? All right, have you had a chance to discuss with him about mitigation?
I have, Your Honor, yes. We've discussed that at length ever since being appointed on the case.
All right, the court is calling 2024 CR 3093, State of Texas versus Dylan Christopher Bell. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense,
Renee Munoz.
are you Mr. Bell?
Yes, ma'am.
All right, and Mr. Munoz, you were appointed to represent him. I know from our last time we were here, the court sort of insisted that he give you more time to perhaps present mitigation evidence for him.
Yes.
And at least give you 10 days. I know he was balking a little bit at that, but ultimately he decided to give you more time. Is there something you would like to place on the record?
Yes, Judge, just briefly, I did speak with my client about the 10-day notice requirement for substitute counsel on a matter that's being set, especially something like sentencing. Did stress the importance of allowing me time. We have met on that date as well as today, and I have been working on his case aside from that. So speak with my client about those preparations made. I believe he's comfortable to proceed at this time, Judge. He's been in custody for the last 177 days pending this charge. So I think that's his wanting to get the sentence done over and done with, Judge. But we're respectful of the court's consideration, allowing us time that we need.
All right, thank you. And counsel, were you able to review the criminal history?
Yes, I was, Judge.
All right, state. All right, according to the plea that you entered into on May 9th, you entered a plea of no contest. The court found that there was sufficient evidence to find you guilty. However, the court deferred finding of guilt as you had applied for deferred adjudication and for community supervision. According to the plea, punishment is to be assessed at 6 years in the prison. The state is opposed to your application, and this will run concurrent with County Court Cause number 727864. All right, state you're opposed?
Yes,
State, you may present.
we don't have any witnesses, Your Honor, but argument.
All right, defense, do you have any witnesses?
No witnesses, Your Honor, only argument as well.
All right, state, I'll hear your argument.
Yes, Your Honor, just due to the fact that this is a burglary of a habitation, this person actually was inside the home when it was burglarized. The reason that we have a reduced sentence here, the state believe that they took into consideration of the fact that the individual left after he was yelled at by the homeowner, but also tried to take the car. And that's where the restitution of $248 comes from, Judge. So that's why the state is opposed.
All right, defense.
Yes, Your Honor. My client is 21 years old. He's had no previous felony convictions. In fact, he was placed on deferred adjudication on the misdemeanor case. My estimation is they're wanting him to pay restitution on it, learn from it, grow from it, Judge. And speaking with my client, I spoke to him about his upbringing because the juvenile offenses did want me to.
All right, everyone, please make sure you whisper.
The juvenile offenses did want me to delve in deeper as to his home life was like back then. He stated that he did not ever have contact with his father whatsoever. He had 2 brothers and a sister, and his mom was raising them all. Admittedly, she worked full time to support and raise them, so we didn't have a lot of parental supervision growing up. Essentially, he would go to school, go home, hang out with his friends, do drugs, skateboard, do things of that nature. He started off using marijuana and cocaine at the age of 15 with some peers that he was hanging around with. And that usage has progressively gotten worse and worse over time. He's admitted to me, and he's being honest and truthful with the court, doesn't want to shun that. He had been using methamphetamine quite often. At the day in question of this offense, he was high on methamphetamine. He stated that he wanted to get the car just to go somewhere and drive so he didn't have to walk. He didn't want to resell it, didn't want to do anything with that. So just the nature of that has me going to the fact that I don't know what he was going through his mind at this time, but obviously it wasn't rational thought. He was in the house. He admittedly saw there was someone there, wanted to get out, try to get the keys, try to take off in the car. But none of that was done. Nothing violent was done. It was not assaults. It was not him wanting to prey on another person. It was just him, I believe, being high on methamphetamine, and there's a causal link between the offense and those dependency issues, Judge. He's 21 years old, still going through some immature thoughts and facts. He's been in custody ever since this offense took place on December, Judge. So he's been in the Bexar County Jail 177 days. He's had a lot of time to think about his life. He's never been confined like that, and he has never been to prison before. I think that was a good shock to his senses that he was in custody for that long. He stated that he wants help with methamphetamine usage to get a handle on that, on those issues that we believe are causing him to appear the criminal justice system, Judge. It was placed on deferred adjudication, county court number 8, cause number 723371. He was granted 6 months deferred on that case, Judge. Being that the DA's offered him deferred adjudication and didn't merely time serve him, I think goes to an indication that they want to work with him on a community supervision basis. I do know that the listed offense is serious, being in someone else's home, and I did stress that with my client. He stated that, you know, if he had the opportunity to get help in the future, he can see clearly he can be a contributing member of society and not a detriment to society where they're having to pay for his stay at TDC, but instead allow him to grow and address the root causes of his issues, Judge. So this is why we're respectfully asking for the chance of community supervision. He's been in custody for the last 6 months. He's 21 years old, never been previously convicted of a felony, Judge. So I don't think it's too late to help this young gentleman to change it, hopefully change his life around.
All right, so here's my question. He's had violent offenses in the past, is that correct?
I believe just one assault family member.
He was an assault that's not
That
associated with this case, and he also has an assault public servant that I believe was dismissed.
was dismissed, Judge. That's correct. I believe the juvenile offense was when he was the misdemeanor assault was when he was a juvenile, Judge, and he was on juvenile probation for that. I just think that the lack of supervision at a young age, not having his father and having his mom just work full-time job and then have the 3 kids that he wasn't supervised. He thought he could do whatever he wants. No, there's society. There's rules, there's laws. And, you know, he fell in with the bad crowd, starting using drugs progressively, cocaine when he was 15. He's never had the chance for drug treatments. So we're just asking for a chance at some treatment, Judge. I don't believe he's going to get the sufficient drug treatment at the Texas Department of Corrections.
Oh, they have the therapeutic community, but
I just need for the juvenile adult public servant, he was on a top of probation.
all right. Anything you wish to say? You want to raise your right hand? You solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Dylan Christopher Bell.
All right, you need to keep your voice up so the court reporter can hear.
Your Honor, I've been thinking about everything I did through the stay in jail, and I just haven't had the chance to go through treatment. And I believe that this offense that I committed was because of me being on drugs, and I wasn't in the right state of mind. And I've been thinking about it long and hard for the last 6 months. I've been incarcerated, and I just don't believe that prison is gonna be the thing that helps me.
Oh, a lot of people, I can tell you this, everybody over in the box, they don't think prison is going to help them. I don't know anybody
Yes, ma'am.
who goes to prison who thinks it's going to help them. Even people who are charged with murder and are found guilty of murder. You know, at some point you could get probation for murder. And I know some people who have been convicted of murder, and you know what they say, you know, prison is really not the place for me. It's really not going to help me. I need to be on the outside.
And Judge, I think that also something he's alluding to, that if convicted and put into prison, he would be a convicted felon at his young age and trying to get a job and trying to do anything with housing. He's just going to be pretty much kept down in society. Whereas if given, say, a deferred, is not a final conviction, he can work his way off to that, pay restitution, make things right, do community service, get back to the community. And that would be a good test of him. I've already explained to him that if he doesn't fulfill the terms of deferred, that she can send you to the full range of punishments and indiscriminately send you to TDC, but he's asking for an opportunity to make it right, make the community better, and also make himself better, to not just be a detriment where he's cycling in and out of the criminal justice system because he's had a conviction, he can't get a job. So we're asking for just at least the slightest hope to keep his record somewhat clean, and have him work his way off this deferred over the years for hopeful dismissal.
All right, any questions, State? I have a question. Why are you in red?
I'm in red because I'm in segregation.
Why are you in segregation?
In segregation, because I had gotten into the fight and they punished me. More so I had gotten assaulted, but they had punished me and put me into segregation for 15 days.
Last time, Judge, he had the bruise under his eye. Remember? You guys?
Oh, yeah, I remember that. All right, so if the deputies were to let me know why you're in segregation, would what you're telling me
Yes, ma'am.
comport to their system?
Yes, ma'am.
If,
Yeah.
if Tyler, the Odyssey system will let us see that?
That would be nice. Yes.
All right,
Good answer.
Deputy Laura?
Is this for, he's in red for disciplinary?
Reference to that probably, but let's just know.
I don't know if that's the case or not. All right, just have a seat. I need to think about this for a moment.
Yes, ma'am.
Yes, Your Honor. Thank you.
Who's here on Christian Smith? Christian Smith? Oh, that's the one where we're trying to figure out.
So the two people that are in charge of pretrial diversion program, Judge, I'm waiting for that response.
All right, so Christian Smith, just wait a moment with us. Do you have to go to work or something? All right, so this is what we'll do then. We'll go ahead and give you a reset and then we'll contact your attorney if you actually need to come back on that day or not. All right. Norma, on Christian Smith, if you'll give him the June 11th reset date and then we'll see what happens. He needs to go to work. All right, are you all ready to proceed on the motion?
Yes, Judge.
Yes, Your Honor.
All right, court is calling 2019 CR 11017W, State of Texas versus Michael Paul Shoemaker. Can I have parties announced for the record for the state?
Daniel S. Clark, which did index.
Defense?
Sean Henderson for the defense.
And are you Mr. Shoemaker?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and cause number 2019 CR 11017W with your attorney, and did you understand it?
Yes, ma'am.
And are you the same Michael Paul Shoemaker who was placed on deferred adjudication in 2019 CR 11017W for the offense of possession of a controlled substance penalty group 1, less than a gram, in a drug-free zone? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 7 on or about the 23rd day of May 2024 at the Port of Galveston, Texas. The defendant, Michael Paul Shoemaker, part of Bexar County without the written permission of the court and or the supervision officer in violation of condition number 7.
How do you plead to that? True or not true?
True.
Your Honor, statement is all the violations.
Any objections to the waivers?
No objection, Judge.
Did you understand by pleading true to violation of condition number 7, the court could find it true, find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 7?
Yes, ma'am.
Court will find violation of condition number 7 true. Is there a proposed agreement?
Yes, Your Honor, it's to alter and amend for MRT within 10 days and GPS for 90 days.
All right. Defense, is that the proposed agreement?
It is, Your Honor, and I do want to let the court know, my client lives in St. Hedwig here in Bexar County. He works as a heavy equipment operator in Bernie and Kendall County.
All right, so why is he leaving Bexar County without permission?
Judge, he was actually going on a cruise, and that was the reason he left Bexar County.
Was that cruise approved by the court?
It was not, Judge.
So is there anything you wish to say?
No, Your Honor.
It would probably be in your best interest, but okay. Probation, what are you recommending?
Probation's recommending the MRT program.
All right, and so this number 1 that's in the motion, I'm not going to consider it as true. But what is happening to the new number one?
Judge, my understanding is that that was out of Galveston. That's ours. I didn't see
Okay.
anything pop up.
And that is correct, Your Honor. The new case is out of Galveston County.
So what is happening with that case?
It's currently pending, Judge. I don't represent him on that, and so I don't know what ultimately is going to happen with that case, Your Honor.
I'm not going to take that in consideration and not consider it. I'm sorry, I'm not going to consider it or take it in consideration since the state waived it. But allegedly,
Or yes, what the new number one is, Judge?
yes, who is
or-
the violation of a protective order with? Did he go on a cruise with the person he's not supposed to be with, allegedly?
Allegedly, yes, Your Honor.
So where do we, off the record, where does it come in that he violated a protective order? How did that happen? That people go on a cruise and things didn't end well?
I'm sorry, Your Honor.
Did he go on the cruise? Because you're saying allegedly he went on a cruise that he had a protective order against. He went with that person on a cruise.
He did, Your Honor. And so when he got on the cruise, since the cruise was leaving the country, Judge, I believe they go through and check everybody's passports. And it was during that process that they found there was a violation or that there was a protective order in place with the person that he was going on the cruise with.
Oh, and he didn't get to go on the cruise? They
He did
stopped him?
not, he did not. It was right after boarding, Judge, that that he was removed from the cruise.
Did he pay for the cruise of the person who he has a protective order against?
Yes, Judge.
He paid for it, or the person who he has a protective order against paid for it?
Both.
Both of y'all paid for it. Did they give you a refund?
Oh, ma'am.
Okay, this is just questions that I have. I'm always curious about things. All right. We can go back on the record. You want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Michael Paul Shoemaker.
All right, why do you have the tape around your wrist? What's going on?
So and when you get booked in the main jail, it's every stage you go through. And
Ah,
I just didn't take it off. They took me straight over this morning. So
okay. All right, this is probation's recommendation and the state's recommendation. What I'm going to do is deny the motion. Is this his first motion to revoke?
I believe it's the second, Judge.
I'm going to deny the motion, alternate amend conditions to ISF cognitive. And with regards to his transfer, does he need his probation transferred?
No, he's living here in Bear County, Judge, so he doesn't need probation transfer.
All right, he's going to remain in custody until transferred. And has he done anything on probation? Has he completed the parenting classes?
Yes, he has, Judge.
yes, ma'am.
All right. All right, is there anything else?
No, Judge, not at this time.
All right, upon release, you need to immediately report to probation. Do you understand?
Yes, ma'am.
And you are not allowed to leave Bear County without the court's permission. Do you understand?
Yes, ma'am.
All right, thank you. Daryl Fields.
Morning, Your Honor.
Good morning. All right, you're here on a bond reduction, is that correct?
Yes, Judge.
All right, the court is calling NYMAG number 752304, State of Texas versus Daryl Anthony Fields. Can I have parties announced for the record for the state?
Let's call it the state of Texas.
For the
Ray
defense?
Lopez for the defense.
All right, and are you Mr. Fields?
Yes, ma'am.
All right, is there a reason for the delay? Is he okay?
Yes. I do also have mental disabilities. That's partially why delay. So
Okay.
bear with me.
No, I just always want to know what's going on. That's why I asked.
Thank you.
Okay. All right, we're here on a motion to reduce bond. State, have you had a chance to review the motion?
Yes, Your
All right, is there a proposed agreement?
Honor. No, Your Honor, I hear this on the.
Ah.
This morning, there was no drug class.
All right, so what is going to happen with this case?
Judge will be sitting out there until we get drug labs back. We hear back whether or not we're gonna get tested. My understanding is that it got sent out, but so far nothing's come back.
And when was it sent out?
Close to the offense date.
Okay. All right. What is the defendant's criminal history?
As far as I could tell in JD, there was a bunch of that. The only other thing I see, I think judge is an outlawed road vehicle case.
All right. And if you want to place on the record, counsel?
Sure, Your Honor. Judge, we're here on that writ for habeas corpus. My client was arrested and incarcerated for this offense back on February 21st, 2024. Since that time, we're here on June 5th, 2020.
June 6th.
2024. And since that time, there has been no indictment, and we have looked through the records, myself as well as the assistant DA, and found no PR bonds have been granted. So we'd ask that the court release him on his own personal recognizance. As he's not been indicted in the state, he's not ready for trial.
Where would he be staying?
I'm not sure.
Do you have a place to live?
Yes, ma'am.
Who would you be staying with?
I will be staying with a very close church elderly person that is on the west side.
Okay.
And yes, I do have transportation to get to court.
Well, let me ask you this. The person that you're going to be staying with, have you asked them if you can live with them?
I have been living with him off and on. And he did have some medical complications while I was in jail.
Mhm.
So so that's where I stand on that. I do have, I did get approved for lifetime and for lifetime recovery, and is willing to do that, go there for a place and do that.
All right. So
If-
then this is what I'm going to do. Because I want you to be in a stable place. I'm going to grant a PR bond. I'll have the fees waived. I'm going to ask for a referral to Center for Healthcare Service or some sort of mental health treatment. And he's going to be transported to lifetime recovery. And we'll do drug testing. And I'll ask that the fees are waived.
Thank you.
May I ask
Yes,
a question?
yes.
Um, with that,
Okay, I'll go through each one of them. So a PR bond, this is what that means. I'm going to waive the fees of that. So that means that you're not going to be required to come up with money in order to be released from custody. The reason why that's being done is because legally, because nothing has happened with your case in 90 days, legally, I have to give you a bond
Right.
that you can make. And so based upon what your attorney has said and based upon what you said to me, the only bond that you can make is a PR bond, which means you don't pay anything because I'm saying that the fees are waived. I'm going to ask that you be referred to Center for Healthcare Service or either to some place for mental health treatment because you've expressed to me that there are some mental health issues.
correct.
Then, so you'll have a place to stay. You've informed me that Lifetime Recovery is willing to let you stay there. So I'm going to ask that you be transported or Lifetime Recovery will come and pick you up from the jail. And that's where you'll be staying at Lifetime Recovery. And then I'm ordering that you be tested for drugs. Lifetime Recovery will do that, but I'm putting that in the order. And normally you will have to pay for that, but I'm asking them that they not charge you for that.
Okay.
All right. Is there anything else you don't understand?
No, I think you answered all my questions correctly.
All right. You're welcome. Make sure you're not allowed to live with that person you were previously living with. You're going to be at Lifetime Recovery. If there is a problem with Lifetime Recovery, just come back to the court before you decide to move or do anything of that nature. All right.
All right. And And I know lifetime is a 45 to 90-day program.
Mhm.
Will they help me transition after the 45 to 90 days?
Yes.
Okay, thank
All right.
you.
And Ms. Ferguson, on this case, even though it's pre-indictment, can you give them maybe a 65-day reset just so we can keep tabs on him to make sure that everything is going well? All right. All right.
August 8th or the 15th.
Council, August 8th or August 15th?
Check on my calendar.
You're welcome. Thank you. Are you all ready on Elisa Hernandez? Thank you for your patience, Mr. Piker.
I see you for busy.
Well, you know, the way Tyler has done the system, it's just going to take some getting used to.
It's no better in the private sector.
Oh.
We have clients that I know that I have cases on that have no file is found. So they'll be glad to hear that.
All right, who's the prosecutor you're working with? All right, so this is the third violation report, and they're saying that your client does not report.
Yes.
So what's going on?
Well, fortunately, we do have a pretty good update. She was in jail up until May 16th. She suffers from major depression. She was not on her medication. She was living under a bridge. She didn't have her phone. It was stolen, broken, I don't know, but it's gone.
Mhm.
On May 16th, when she got out, she was picked up by her brother, Julio Hernandez, which I will call up here for you to talk with.
Okay.
He has taken her in. She lives with him. She's back in the stream of things. Was with probation on Friday, for her recollection. She got a new probation officer, Freddie Williams, has his phone number. And right after she got out, she also went back to her doctor. She calls her Dr. Yolanda at the Kellum office on Marbach, who put her back on her Zyprexa.
Mhm.
So she's back on medication. She did come to court. She's come to court every time that, except for when she missed the lift. But last week she was here and she was insistent that she had court. I was the one that told her, I can't see where you have court. It's the 25th, and told her to go, and you're aware of that situation.
Yes.
But she's been here today. She seems to be doing better since she's on the Zyprexa. She does come to, she's been in contact with me
All right, so when
since
is
she
the,
got out.
since she's been released, has she contacted Mr. Williams?
On Friday, just Friday, 6 days ago, according to her. She couldn't remember quite what it was, but her brother said you didn't have the phone long enough to talk to him before that. But he's saying it's been since Friday, but I can have him brought up as well.
Yeah, let's have him brought up.
Hernandez?
State, are you, based upon so far what you've heard from Mr. Piker, are you seeking to,
A body.
you want a bond increase?
No,
No.
just based off of what I've been hearing, it seems pretty straightforward that she is now kind of getting back on track.
Okay. All right. So what is your name, sir?
Julio Hernandez.
All right. And we're not on the record. I'm just trying to gather our information. So what is the relationship to Mr.?
That's all.
Yeah. What's your relationship to her?
I'm her older brother.
All right. So is she staying with you now?
Yes.
All right. And
Not
are you
2 weeks.
helping? That's okay. No, I appreciate it. Are you helping her with medications to make sure she has those?
Yes, I keep on telling her, who's your doctor? I need to know what your medicine is. When you run out, so we can go pick it up. So I've been kind of keeping on with that.
And you know who her pretrial officer is?
No.
All right. So,
I think you do. That was the man she met last Friday.
Yes, she's been talking to him, but I've not met him yet. I don't know who he is.
all right. So counsel, what probably needs to happen, and of course, this is her case, not yours. But I'm trying to make sure that everything stays on track with her mental health, and I know the state is as well. Counsel, you probably need to give him the phone number and information for Freddie Williams. so that if something were to happen, she's not on her medication or she's missing, then you can call Mr. Williams and say, this is what's going on, and let the court know. Because I can tell you, neither the state's position or my position is to have her locked up and not receive the treatment that she needs. Before, the state has just informed the court, at first they were looking at a bond increase, but now, since we know everything is back on track and the issue is with her mental health, and it wasn't just her just blowing off things. So what I'll do is I'm going to continue on bond with the same conditions. They'll continue. She has a no contact order with Lonnie Rodriguez and no possession of firearms. So those are her conditions. And defense counsel will give you do you need a sheet of paper or anything for the information for Freddie Williams for him?
No, I have it, and she has it in her phone now as well. I saw it.
All right, so defense counsel will give you information, and I'm sure you have his information as well. If there is an issue, you let the court know. As I said, we're trying to make sure that she stays on her medication so that she's not in custody necessarily while she's waiting for this case to be resolved.
Okay.
All right. Thank you so much for coming down, and thank you for your help.
Thank you.
All right, and so this other matter, because she is on bond for an injury case.
Yes, sir.
So has anyone sought out mental health court to see if that's a consideration potentially for her?
I haven't.
Talked about it just yet, Judge.
All right, so if y'all will see about that, because otherwise, if you wait till perhaps she's indicted, then the ball is rolled into another direction, and who knows, the state may end up saying she would be a good candidate for mental health court, but then there's a lot of extra loops to jump through for that.
And possibly when I talk to Lisa, I'll get more information on Dr. Yolanda to see how long she's been treating, because maybe her input into this may lead us to understand more what allegedly happened on the incident date. And we can consider that too.
All right. Is there anything you need to address with me?
No, that's good. Thank
All
you.
right, just make sure you stay in contact with everyone. That's the
I will.
issue. When you're not in contact,
Yeah,
that's when people start to worry, what's
Yeah.
going on?
they'll start keeping contact with us.
All right,
Since she's been out, she has.
Yeah.
yes. All right, thank you. Keep up the good work, okay?
All right,
Thank you.
Thank you.
thank you.
All right,
You
so
said what, ma'am?
Officer William, hi.
Oh, I'm sorry.
So they just showed me a message where they were, I believe she was in touch with her previous officer, and the previous officer gave your number. So
Mhm.
when would you like to see her?
If she can report, honestly, I guess tomorrow, because I'm here in office.
All right.
Okay.
Yes,
Sir,
yes.
Yeah.
all right.
Sure.
So she's gonna report there tomorrow. What time do you want her to report?
It doesn't matter. Anytime between 9 and 2 is fine.
All right, so you need to report between 9 and you say 9 and 2?
Yes, ma'am.
All right, so find out from her brother if he can have her there no later than 10.
Between 9 and 10 tomorrow, probation?
Yes. Yes.
All right, so they'll be there at 10.
Okay.
All right, and do you know the location?
I'll tell them.
Yeah.
It's where probation is, right? On Comel.
All right, it's on Kamau.
Yes,
All right.
222.
All right, so Mr. Williams, if they're not there by 10, just let the court know.
Okay. Yes, ma'am.
All right, thank you so much, and thank you for zooming in right away. I really appreciate it.
Oh, yeah, no problem, ma'am.
All right, thank you. Thank you.
Bye.
All right, are we ready on Abel Montez?
We are, Judge. I think we are finally.
Yes, this is the last one.
The best for last, huh?
Okay. All right, court is calling 2022 CR 1164, State of Texas versus Abel Montez. Can I have parties announced for the record for the state? Defense?
Ron Ross for defense.
Judge, I need the volume up a little bit, please.
All right. Can you all make sure you speak up? All right, Mr. Montez, can you unmute?
Okay,
All right, Mr. Montez, I'm showing you what's entitled Defendant's Consent to Appear by Video. Did you
Correct.
review that with your attorney? Did you understand it? And did you sign it?
yes, ma'am.
Any objection to the defendant appearing by video, state?
No objection.
Defense?
No objections.
Court will find that defendant has knowingly and voluntarily waived and consented to appear by video. Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, I have, Judge.
Court will find that the state is in compliance with discovery. Mr. Montez, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do.
State, are you proceeding on the indictment as presented?
Your Honor, we'll waive the repeater enhancement and then proceed.
Any objection?
No objections, Judge.
Mr. Montez, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with continuous violence against family? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Montez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishments be assessed at 8 years in the prison. There are no applications. This will run concurrent with Comal County cause number CR 2020265. State will take in consideration 2022 CR 1781, 2022 CR 1168, 2022 CR 3621. There's an affirmative finding of family violence and there's to be no contact with Nicole Martinez. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition or be designated as primary custodial parent? Did you understand?
Yes, ma'am.
Did you understand that to be the entirety of the plea bargain agreement?
Yes, ma'am.
Defense?
Judge, I'm not sure about the case numbers. That one you said 2022 CR 28, something 28.
No, 1781 and 1163 and 3621.
That's it. Yes, ma'am. That is a plea bargain agreement. Yes, ma'am.
State?
Yes, Your Honor.
Showing you the paragraph, Mr. Montez, entitled Waiver of Appeal paragraph. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest or guilty.
I'm sorry, what?
No contest.
State any evidence?
Your Honor, we offer State's Exhibit number 1 and all attachments.
And no objections.
Mr. Montez, I'm showing you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Did you understand? You're muted. Press the space bar. It's the longest key on the keyboard and hold it down.
Okay, sorry about that. I didn't have the keyboard to unmute.
All right, don't touch anything else. All right, did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are we proceeding with sentencing?
We are, Judge.
All right,
We'll waive PSI.
All right, the court will follow your agreement, sentence you to 8 years in the prison, give you credit for any time served. This will run concurrent with Comal County cause number CR 2020-265, 2022 CR 1781, 3621,
Yes, ma'am.
and 2022 CR 1163.
Yes, ma'am.
There's an affirmative finding of family violence and there's been no contact with Nicole Martinez. Showing what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, and also because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Montez, you're gonna have to make better decisions. Otherwise, you're gonna find yourself living at the prison. Do you understand?
Yes, ma'am.
All right, good luck to you.
You have a good week, ma'am.
All right, you too.